You know, that's what I'm doing.
Because you've got your phone out, you're pointing your camera towards personal cars.
Taking pictures of the fence.
What?
I'm taking pictures of the fence.
Why are you doing it?
What's it got to do with you? Do you want to come round to the side?
No, as well.
Alright.
What are you doing?
Taking pictures.
Of?
The fence.
The fence? Why?
I like fences.
Like fences?
I went to the reception, she said it's fine.
Right, it's not fine, is it really?
Is it not fine?
No. Current threat levels at the moment, isn't it, for the police, and you're filming private cars?
Can you just step back a bit?
No, not at all. What's your name, buddy?
I'm not telling you my name.
Not telling his name? Right.
You don't need to, but you just need to grow up a bit, don't you?
Really?
Yeah. Because all you're doing is just trying to antagonise people.
I'm not trying to antagonise anyone.
Yeah.
No, I'm not.
Yes, you are. You stood filming personal people's private cars.
I'm not filming the cars.
You sat there with I've just watched your screen. You're videoing.
I know I'm videoing.
Exactly.
But I'm taking pictures of the fence.
Yeah.
I went to reception. She said it's fine.
PC Morris immediately uses a common excuse by saying, "You can't film a police station because of the current threat level." However, the facts tell a different story. There hasn't been a successful terrorist attack on a UK police station in more than 10 years. Since 2010, none of the known terrorist plots involved someone filming a police station from a public pavement. The Metropolitan Police, the Home Office, and the NPCC have all confirmed in their official guidance that taking photos or recording police buildings from public places is legal and, by itself, is not suspicious. Every year, thousands of tourists, vloggers, and members of the public record police stations without any issues. Yet somehow, auditors are often treated as if they are a security threat.
You take a piece of people's personal car
I'm not taking pictures of cars.
when the threat level is very high.
Even if I was taking pictures of cars,
Yeah.
is it against the law?
You can film. I'm just asking you why with the current threat level. What do you do for a living?
It's my own business.
Your child.
Am I a child?
Yeah. You act like an adult. Then.
Do you need retraining now to deal with the public?
No.
I think you do.
Not really. It's all you, mate.
What?
What's up with you?
Nothing.
You got a good photo there?
Video, mate, video.
Video. You do realise that without my permission as a police officer, you cannot use that video, and I can confiscate that as well if I need to.
I don't think so.
I do.
What law is that?
That'll be the law and the pace that I'm going to find out at this moment in time.
Alright, am I being detained?
At this moment in time, you are.
For what?
Well, I'm going to get the code at this moment in time, and I'm going to search it under an act.
Alright, yeah.
And then you'll have to provide your details as well.
No, I don't.
Yes, you
No, I don't.
When you're detained, you do.
No, I don't.
PC Morris appears unsure about what legal powers he actually has. He confidently claims that FTA cannot use the footage without his permission and even says he can confiscate the camera if necessary. That is simply incorrect. UK law does not give police officers ownership over footage recorded in public. A camera can only be seized if it contains evidence of a genuine criminal offense and the legal requirements are met. Morris then tells FTA that he is being detained. When FTA asks the obvious question, under what legal power? Morris replies that he needs to get the code first. That response reveals the real problem. He detains someone before knowing which legal power, if any, actually applied.
Are you recording? You should inform me, shouldn't you?
It's there. Should
It's there. I know you got a camera, but I don't know it's on, do I? Until you inform me.
We're going to do that now. Alright then, at this moment in time, you're staying under Section 23 of the Terrorist Act, okay?
23?
Section 43 of the Terrorist
43,
Act.
right, yeah.
43 of the Terrorist Act. So basically, you're ballied up at this moment in time and you're taking personal videos of that, okay? So I'm going to ask you to remove that at this moment and give me your personal details.
Right, under section 43, I don't have to give my details.
Well, you do at this moment in time. If you fail to provide out under this search at this moment in time, I'll just arrest you, mate.
For what?
For this moment in time, for a possible terrorist act.
So you think I'm a terrorist? I'm overt. I'm not covert.
Okay.
Have you read the memo
What memo?
on people filming around police stations?
I have.
Yeah?
Bit suspicious though, isn't it, pal?
No, it's not suspicious, because I've told you exactly what I'm doing.
You know, filming fences.
Yeah?
Why?
I like fences.
Why do you like fences?
Because that's what I'm into, that's what I do in my free time.
Where's your best fence then that you've done? Show me other videos then of your best fences.
I like police fences.
Like police fences?
Yeah, yeah.
Alright, so that's a bit suspicious then, isn't it?
Oh, is
Right,
it?
right.
After speaking over the radio, PC Morris finally names a legal power, but he still gets it wrong. He first mentions Section 23, which is unrelated to terrorism and does not give him the authority to detain someone in these circumstances. When FTA questions him, Morris quickly changes his answer to Section 43 of the Terrorism Act. Section 43 requires an officer to have reasonable suspicion that a specific person is involved in terrorism. Simply carrying a camera or standing outside a police station does not meet that legal test. Morris then demands FTA's personal details and even threatens arrest if he refuses. That goes beyond a simple mistake. Under Section 43, officers may carry out a search, but they cannot force someone to identify themselves.
Okay, before a search then, you got anything that's going to harm you or me or any of my colleagues?
No.
Okay, do you want to take your hands out your pockets then for us?
Yep.
Make sure you get my good side.
Turn round.
Why's that?
To get your good side.
Good side's good side. I reckon we got 2 phones on you?
That one's for phoning, this one's for taking pictures.
What, you said he was videoing, not taking pictures?
Well, you can take stills of the videos, can't I?
Oh, I see. So you tried to correct me before, but you were wrong yourself, wasn't you?
I'm not wrong, am I?
No, you was, wasn't you? Jaguar key. You know what they say about people who drive Jaguars, don't you?
What's that?
You drive Jaguars. Right, those going between your legs, do not kick out, it'll be your... Right, I just think you should leave.
Can I put my stuff back in my pockets?
What's it's your stuff?
Yep.
Right, you've got another offence now, I think you should move on.
Once the search finds nothing suspicious, PC Morris should have ended the encounter. The purpose of a Section 43 search is to confirm or remove suspicion. If nothing is found, the officer should simply allow the person to continue on their way. Instead, Morris continues treating FTA like a threat and tells him, "I think you should leave. You've got enough footage." That request has nothing to do with public safety. It appears to come from frustration rather than any legal authority. FTA had every right to remain in a public place and continue filming. A professional officer would simply have said, "The search is complete. You're free to go," and ended the interaction.
I walked on there.
Good, bye-bye.
Look at this fence, this is interesting. Just going to get all the fences as I walk down, is that alright?
Switch it off, mate, you don't need to.
You can't tell me to switch off.
Oh, you're right, I can't, but just switch it off, isn't it?
And you never got me details, did you? Because you can't get me details. Under Section 43 you can't. Off you pop!
I'm just here with an update from the solicitors who've basically confirmed that they've received a response from the defendant, which is the PC Morris, PC 16660 from Longside Police Station. They have rejected the Part 36 offer and their stance on liability is not changed. And the only way to progress is to issue court proceedings.
This letter from FTA solicitors reveals more than it may seem at first. It explains that the police rejected a Part 36 settlement offer. In legal terms, that usually means the other side has decided not to settle and is prepared to fight the case, even if it becomes more expensive. Part 36 offers are designed to encourage early settlements and reduce legal costs. When a police force rejects such an offer in a case involving an unlawful stop, detention, or search, it can be a risky decision. Rather than strengthening their position, it often encourages the claimant's legal team to continue the case through the courts. Clip 6. In the end, the detention had no solid legal foundation. Every important requirement was missing. FTA solicitor explained that there were strong prospects of winning the case and suggested that poor police procedures could make the entire detention unlawful. FTA later confirmed the outcome himself. When someone suggested he should sue the officer, he simply replied, "I did, and I got paid." That short response says everything. The legal arguments proved successful, and the police force ultimately had to pay the price for its actions. This case is another example of officers relying on powers they did not fully understand, making decisions without proper legal grounds, and being held accountable afterwards. That's all for today's video. If you enjoyed this episode, please like, comment, and subscribe. Your support helps me continue creating independent content. Also, don't forget to check out Free Times Audits. You'll find a link to the channel in the description below. Be sure to show your support. Thanks for watching, and I'll see you in the next video.